Brilliant. Welcome and hello. My name is Leonie Tanzer, and it's a pleasure to see so many of you joining today's webinar on the applicability of the UK Computer Misuse Act 1990 onto cases of technology-facilitated domestic abuse and violence. It's quite a long title for today's session, but we promise to not spend the whole hour just talking at you, but hopefully spend around 25 minutes having a Q&A session so you can ask us any questions that derive from our presentation today. And for everyone who joined today, you may ask the question, who are the people in this webinar today? So we're a group of researchers from both University College London as well as Queen Mary University of London. My name is Leonie Tanzer. I'm a lecturer at UCL, and I'm also the principal investigator of a project called Gender and IoT, which I think was the starting point for this research grant. We also have Francesca Stevens with us. Francesca is a research assistant at UCL. She's an incoming PhD student also at City University, and she's a volunteer for the National Stalking Helpline. And her background is a lot in criminology and criminal justice. And she's also interested in cyberstalking. So she has done the bulk of the research and will also present the bulk of the research today. We then have Frances Ridout with us. She's director of the Legal Advice Center, but also, and really important for us, she's a practicing barrister. So because this webinar and this research was very legal focused, it was fantastic to have Frances with us. She specializes in image-based sexual abuse cases such as upskirting as well, and leads the SPITE project at Queen Mary Legal Advice Center, which offers free legal advice for revenge porn victims. And last but not least, we also have Professor Shane Johnson with us, who sadly cannot be here with us today. And Shane is a professor in future crimes and the director of the UCL Dawes Center for Future Crime. So he brought more the policing aspect to this project and worked closely with us around issues around the future of tech abuse as it occurs. So now that you know who we are, and as I said, I really want to stress this probably derived of the work that we did as Gender and IoT, but the core foundation for the kickoff of this project was actually that we were granted a funding by the UK Home Office on the Domestic Abuse Perpetrator Research Funds that funded approximately over 12 projects across the UK. And they had a really particular interest on emerging methods of abuse in the context of domestic violence and abuse. And because the four of our interests is very much on image-based abuse, technology-facilitated abuse, we were coming together to analyze how tech abuse in court cases is being dealt with. And so just to give you a snippet of what we will talk about, what we have done over the last months is to do a systematic legal database analysis of court cases in England and Wales where the Computer Misuse Act was referenced. And the Computer Misuse Act is a very critical topic here because it's actually targeted at cybersecurity, but we are wanted to analyze whether it also is applicable to domestic abuse cases that use technology. And we also did a systematic legal database analysis of a time-limited sample of court cases that involve domestic abuse cases and wanted to see whether the Computer Misuse Act would have been applicable in these instances. So with that, I want to briefly just mention what tech abuse is when we talk in this case. And I normally tend to say that it's a really big bucket. And what I mean with that, and what we mean with that, is that it ranges from anything that involves digital technology, may it be a smartphone, a laptop, a tablet, but also emerging technologies such as drones, smart internet connected devices, so-called the Internet of Things, but also play consoles such as Xbox, etc. So we were interested in, has tech abuse been found applicable to Computer Misuse Act cases, or rather, has the Computer Misuse Act been used in tech abuse cases? And to make this more clear, I want to hand over to our legal expert, Frances Ridout, to give a bit more flavor of the legal context here.
Hello, good afternoon, everybody. So the Computer Misuse Act is a really old piece of legislation. Let's just remind ourselves that the World Wide Web was launched in 1989, and this act was obviously dated 1990. It was developed to target wrongful conduct in an increasingly computerized society. But tech abuse, as Leonie says, just wasn't really part of that. It isn't part of enterprise. It happens in relationships, and this statute is essentially formed to look at enterprises and how computers can be misused. Now, in short, it has five main cases, five main criminal offences that it covers. It used to be 3, but these were developed into 5 in more recent times. So firstly, and perhaps most importantly, unauthorised access to computer material. And this section 1 offence carries a maximum sentence of 2 years, which I'll go through the maximum sentences with you just to give you an idea of where they fall on the different levels of seriousness. Section 2 is all about having unauthorised access to the computer, so just like section 1, but with that additional intention to commit or to facilitate somebody else committing further offences once you've gained that access. And that maximum sentence is 5 years imprisonment, so you can see it's a bit more serious in terms of a level of offending. Section 3 carries the offence of unauthorised acts with intent to impair or being reckless as to whether there's impairing in the operation of a computer. Now, this is a much more serious offence that carries a maximum sentence of 10 years imprisonment. And then we've got section 3ZA, the 4th offence in statute, unauthorised acts causing or creating serious damage or significant risk of serious damage. And that is the most serious offence within the statute, carrying a maximum sentence of 14 years imprisonment. And then the last section, section 3A, is all about making or supplying or obtaining articles or materials that can be used to commit an offence in the previous section. And that carries a maximum sentence of 2 years imprisonment. Okay, so those last 3 offences that you can see on the 5 listed on the slides, it used to be 1, and then they went into a bit more detail and opened those up. So bearing that in mind, I just wanted to touch quickly on the legal systems to give a bit of context. Yeah.
Francis, could we have a request to speak a bit up to hear you better?
Oh, sorry.
Thank you.
I'm just going to touch a little bit on the legal system in England and Wales so that hopefully gives you some context to the research that Francesca will talk to in a moment. First of all, it's important to remember that criminal cases, which we're mainly talking about when we talk about the Computer Misuse Act, are the state prosecuting an individual. And by far the most frequent prosecutor from the state side is the Crown Prosecution Service, also known as the CPS. Now, there are some other prosecuting bodies that came up in the course of our research, but by far the CPS is the most common. The other thing that I just want to briefly mention is that the CPS, when deciding, they will be the body who decide which criminal offences are prosecuted, which criminal offences are laid before the court. It's not for a court to decide that. And that's because in England and Wales, we have an adversarial criminal justice system, court system. So that's where the parties bring the issues of dispute to the court to determine, rather than the judge themselves having an inquisitorial role where they are asking for certain pieces of evidence or directing or investigating certain pieces of evidence. And this slide here that we've got up just gives us a bit of context as to the different courts within the system. Okay, so you might think when we're talking, about abuse, that cases would mostly arise in the family courts, but actually we're going to be dealing mostly with the criminal courts. The family court, which you can see on the bottom row of that slide, is actually a closed court. There's no public gallery of standard, which means it's quite difficult to hear the decisions that are coming through the family court unless they've reached an appeal stage, either at the High Court or the Court of Appeal. The Magistrates' Court is really where the absolute bulk of criminal offences are prosecuted. So all criminal offences will start in the Magistrates' Court, and most are dealt with there, particularly what we call summary-only offences, which are the lowest level of offending. The magistrate's court does not record proceedings. So there's no taped record that you can then get transcribed. And the notes made might be made by a legal advisor or the judge or lay magistrates included in the file, but they're not public documents. They're not necessarily publicly available. So it can be quite difficult to find out what's happened in the magistrate's court, although they do have public galleries. You need to be literally going into sitting there to get those results. So the Crown Court will deal with more serious criminal offending, and appeals from the magistrate's court might go to the Crown Court. And this would be where you'd have a jury determining issues of fact, who's sitting with a judge. These proceedings are recorded. So it is possible to get records of them. However, they're very expensive to get transcribed, and they're not readily publicly available. It's something you'd have to specifically look into. More typically, if parties wanted to appeal a case to the Court of Appeal, then they would ask specifically for the transcripts to help them prepare for that appeal. That would be when you would get that transcribing done. And then cases then can be appealed, as I've said, to the Court of Appeal, which has a civil division and a criminal division, and then points of public interest could go to the UK Supreme Court. Now, it's important to mention that most of the publicly available judgments that we've been able to use for this research are Court of Appeal or Supreme Court decisions where the databases, the recorders have thought it is an important decision that should be available for the legal profession to look at, for the public to look at, and that's been where we've been able to infiltrate. So it's usually been when there's been a point of law that's led to some kind of appeal that we've been able to see those judgments. And one thing I will just briefly mention is that particularly with the Computer Misuse Act, there tends to be a lot of what we call extradition cases, which are international criminal law cases. So typically somebody commits an offence in one country, then they live or run away to a different country, and it's about getting them back to the country where they committed the offence to face trial. And those tend to be dealt with in the magistrate's court, with appeals going to the High Court. So that's where that diagram, it doesn't quite go as the diagram shows.
Thank you so much, Fran, for the legal overview, which obviously is really crucial to our research and sort of understanding what comes next. So now I'm going to discuss the research that we've undertaken, and our study has the following objectives. So next slide, please, Leonie. Thank you. So the first objective is to examine the extent and nature of domestic violence cases and IPV cases in CMA offences, to identify how the use of technology in domestic violence cases has evolved over time, and thirdly, to develop an analysis framework to evaluate tech abuse in IPV situations. So we set out to look at instances of tech abuse court cases in England and Wales that were prosecuted using the CMA. This research approach has allowed us to directly address the Home Office interest in studying the technological enablers of domestic abuse and help develop our understanding of tech abuse perpetrators. So in order to achieve our objectives, we conducted a systematic legal evaluation where we methodically identified, extracted and reviewed court cases in England and Wales that were prosecuted using the CMA or involved domestic abuse offences. So in March of this year, we began Study 1, where we conducted a systematic search of 3 legal databases in order to review cases where the CMA was referenced, and this approach has allowed us to examine the use of the Act in previous IPV cases and its relevance for offences relating to tech abuse. So ahead of conducting this search, we decided upon 2 inclusion criteria for the cases that we would look at. Firstly, that the cases were of relevance to the CMA, and secondly, that they took place in a court within England and Wales, so for example, not Northern Ireland or Scotland. There were no time limitation regarding dates because we wanted to look at as many cases as possible since the Act became law in 1990. So we used 3 online legal databases, and these are called Westlaw, LexisNexis and Bailey. And Westlaw and LexisNexis were chosen as they are the leading commercial case law databases in England and Wales, and Bailey because it provides the most complete virtual collection of legal documents available online. So these databases provide users with law reports, which can be understood as a record of a judicial decision on a point of law, and judgments, which are official written records of the court's judgment from a case. And as Fran mentioned, most cases featured in these three databases have been taken from high-level courts. So that's the High Court, the Court of Appeal, and the Supreme Court. So basically, in order to ensure that our search identified as many relevant documents as possible, we simply just used Computer Misuse Act 1990 as our core search terms across all databases with no additional filters. And it should be noted that when we initially conducted this database search, the preliminary search results did not always equal the exact number of individual court cases that we were looking at, because there are, as I think Fran touched upon, some cases have various stages, hearings, and dates relating to the same parties and concerning the same behaviours. So in these instances, we've therefore counted them as one court case overall. So our searches culminated in 82 cases from Westlaw, 9 cases from LexisNexis, and 2 cases from Bailey. So the number of different individual court cases from the 3 databases came to a total of 93. It's important to note that we also compared our search results with CaseMine, which is a commercial AI-enabled legal research tool. And basically through this, we found one extra case which came under the same necessary items, such as that it involved the CMA and that it was in a court case in England and Wales. So therefore, the total number of cases that we examined was 94. So once we had this number of cases, we downloaded the relevant documents, analysing them offline, and we drew upon a thematic framework which we established for this research in order to determine the number of cases out of the 94 that involved tech abuse and IPV. So this framework looked at aspects which included the overview of the case, the relevance of the CMA, if the case was indeed prosecuted using the CMA or if it was just mentioned, what technologies were involved, if IPV was involved, and finally the decision of the case. So then what we then next did was we assigned a colour code to each case so we could stipulate whether IPV was involved, and the breakdown was as follows. 2 cases did involve IPV. There were 84 cases with no mention of IPV, 5 cases where we suspected IPV may have occurred, and then 3 cases of interest. So therefore, to date, this analysis indicates that only 2 of the 94 cases involved tech abuse and IPV of the cases we looked at that involved the CMA. So to discuss these results in a little bit more detail, I'm going to chat a little bit about the 2 cases that involved IPV. So these 2 cases, the first was R.V. Rogers from 2014. And in this case, the appellant, a man named Barry Rogers, he was accused of stalking his ex-partner, Dr. Judson, using electronic means. So when Rogers was arrested in 2011, the police seized 2 computer towers belonging to him, which they examined and found files containing a large collection of personal information about Dr. Judson, her friends and her family, which include emails from Dr. Judson's email address as well as from her friends and family too, and he saved photographs of his ex-partner attending various events. So all of this personal information had been obtained due to Rogers hacking into various computers. And the judge of the case described this activity as a form of electronic stalking. The second case was R.V. Debnath from 2006. And the appellant in this case, named Anita Debnath, and the complainant of the case, Mr. A, were work colleagues. They supposedly had a one-night stand in July 2001, and Debnath believed she had caught a sexually transmitted disease from this encounter. However, Mr. A never had the disease in question, but it was this belief that sparked a course of harassment by Debnath for a year against Mr. A. And this included things like emailing his fiancée, pretending to be one of his friends, telling her of alleged sexual indiscretions, as well as emailing his former employees claiming to be him, which listed ways that he was allegedly harassing Debnath and trying to frame her for harassing him. And she also registered him on a website called positivesingles.com, which was a database for people with sexually transmitted diseases looking for sexual partners. It was interesting that in June 2004 at Leicester Crown Court, because this is a perfect example of a case that had various different stages that took place in various different courts, she did plead guilty, and one of her bail conditions was that she was not to access the internet. However, she reoffended. So in terms of the cases where we suspected that IPV could have potentially been occurring, we couldn't actually confirm this dynamic in all of them due to the court documents available to us, as sometimes the information, as I think Fran touched upon, can be quite limiting. So an example of this is the case of R.V. Khan in 2013, where the applicant Khan applied for permission to appeal against a sentence that she had received for undertaking offences contrary to the CMA. And the background to this case was basically that she was employed in the social services department of a local authority and had access to a database containing personal information. Due to the role, her access was limited for specific purposes, and had signed a systems access confidentiality agreement upon starting this role. However, her partner, who she had 2 children with, had been charged with the child abduction case in relation to a teenager and was being investigated for exploiting young girls. And it turned out there was a lot of information regarding this teenager on the system. So Khan's colleague thought to check the records just to confirm that Khan was not accessing them illegally. And it had been found that she had indeed done this on 32 different occasions over 15 days during the summer of 2011, as well as looking at information about the teenager's immediate family and her partner and his brother too. Khan did admit to her offences, but she alleged that her partner was violent and controlling and had driven her to obtain such documentation, which she said she had done out of fear. So this is an example where obviously, we suspect IPV was involved and potentially she was forced to kind of undertake that, but it's obviously not a simple case of we can confirm that tech abuse and IPV was involved. There's also a few cases of interest, 3 cases, where one case involved a defendant who had previously been convicted of computer misuse relating to tech abuse. Another case where a police officer had used the police force intelligence system to perform checks on relatives. So again, we don't know the details of these relatives. It could be counted as his wife, or it could be, his nephew. We don't know the details there. And finally, a case where the claimant had not only harassed a former female friend for 3 years, and diaries had been found to suggest that he had become obsessed with her. So we think there could be, IPV, some potentially having there, but also that he caused a computer to perform a function with intent to secure unauthorized access to data. So obviously there's CMA offences involved here, but due to the lack of kind of details on these cases, we can't confirm that at this time. So now that we move on to study 2, so basically because the court documents from study 1 did not deliver the amount of information that we had hoped for, we decided that we would conduct a second study. So this was a systematic search of court cases that were of relevance to domestic abuse. So as with study 1, we used the same 3 legal databases, but this time we decided upon 3 different inclusion criteria. So firstly, that the cases were of relevance to domestic abuse. Secondly, that they took place in a court within England and Wales. And thirdly, that the court cases occurred within approximately the last 6 months. So we undertook this in April and May. So that was basically dating back to about November 2020. The reason for this time-limited dip sample approach was because there is a vast number of court cases on these databases where the law report involves some mention or reference to domestic abuse. So because they all come up, obviously in the time that we had, we couldn't kind of look at an unlimited sample. So this search culminated in 30 cases from Westlaw, 21 from LexisNexis, and 56 cases from Bailey. So the number of different individual court cases that we looked at in this study at this point was 107, but then after doing what we did last time with the comparison to CaseMine, we found one more case. So our total number of cases now was 108. So again, like with study 1, we reviewed the relevant court documents, which we downloaded and analysed offline, drawing on a thematic framework, which we established again for this research. And this examined and analysed aspects including the overview of the case, the relevant legislation, whether tech abuse occurred, and any of the further details relating to domestic abuse. So it's important to note as well that many of the cases we looked at were in fact not specifically about 2 people who have been in an abusive relationship, where say one individual was taking the other to court to prosecute them. But instead, these cases commonly concerned either a child or children, and either which parent they should live with, or whether or not they need to go into care or supervision orders need to be made. And actually, domestic abuse was of relevance because it was part of understanding the history of kind of the family dynamic. Or there were many cases where it was about an appellant appealing a decision that had been made, either saying that they were not allowed to have leave to remain in the UK. And then where domestic abuse would be of relevance was the fact that either they were a victim of domestic abuse, so they were saying, they were asking for their decision to be considered, or it's that they were a perpetrator of domestic abuse, hence that affected why they were not given leave to remain in the UK. Okay, so then as with study 1, a colour code was assigned to each of the 108 cases to stipulate whether or not tech abuse was involved. So in total, this time it was 20 cases involved tech abuse. The breakdown of this was that there were 19 which involved IPV and tech abuse, and then one case actually which involved tech abuse perpetrated by a son against his father. And then 67 cases which do not mention any specific involvement of tech abuse, 5 cases where tech abuse we suspected to be involved, and then 13 which don't involve a case of domestic abuse, but they came up because they might have mentioned it in relevance to something else. For example, there was a case where one of the women had worked for a domestic abuse charity, so that's why it came up in the search. And finally, 3 cases of interest that need to be investigated further. So there are a wide range of offences that occurred within the 19 cases that involved tech abuse and IPV. So obviously, in the time that we have now, I can't run through all of those cases in a lot of detail, so I'm just going to give a brief overview of a couple of them now, just to give some sort of examples of the type of offences that we were seeing. So in the case of R versus T, this involved a divorced couple where the man had continued to contact his ex-wife by text message, and many of these were explicitly sexual in nature and were sent late at night or early hours of the morning. She had repeatedly asked him to stop, but he continued to obsessively contact her. There was another case that occurred in the High Court, which concerned 3 children and their parents. And this case involved allegations of domestic abuse, controlling behaviour, and also transnational abandonment of the children. And the particular relevance here is that the father sought to control the mother in various ways, including preventing her from having a bank account and installing a camera within the family home to spy on her as well. The case of F versus M involves a husband, wife, and their 2 children, where the husband took away all of his wife's means of communication. So this include access to her email, her Facebook account, and her mobile telephone. So she was entirely isolated. The husband also sent messages to his wife's parents, pretending to be from his daughter, so they would to affect their relationship and to distance her even more. The final case I'm going to touch upon now is the case of Shayna Grice and her former boyfriend, Michael Lane, who sadly murdered her in her home on the 25th of August in 2016. They had been in an on and off relationship for about a year, and throughout this time, including when Grice had resumed a relationship with her long-term boyfriend, Lane continued to, he physically assaulted her, he stalked her, he slashed the tires of her car, and he placed a tracker on her car, which obviously made up a big part of the stalking and kind of how he facilitated that, and also continued to make a series of phone calls to her, which included just heavy breathing noises continually down the telephone to her. And I'm actually going to touch upon this case a little bit more in a minute. So that was, just a really kind of brief overview of some of the tech abuse offences that we saw in the court cases. So now I'm going to move on to the discussion after that really quick overview. And basically, to conclude, study 1 has highlighted the extent and nature of domestic violence, IPV and stalking offences within CMA court cases. But it's also shown us the type of offences that are more related to the CMA, which include unauthorised access to databases in employment contexts, obtaining files and documents without consent from partners, and issues relating to police intelligence systems. So therefore, the analysed CMA court cases which do relate to domestic violence and IPV often involve data breaches with the motivation to obtain information and keep it. However, study 2 showed a slightly different dynamic, as across the 19 cases which involved tech abuse and IPV, as well as the additional 5 suspected cases, the nature of the tech abuse forms was centered around control and manipulation. And this was seen through perpetrators checking phones, excessively calling or texting victims, listening to phone conversations, installing monitoring equipment like the cameras and trackers I've mentioned, and deliberately withholding access to devices. And what we found was these types of findings really echo existing studies on the nature of tech abuse, which show us that the purpose of the abuse was rarely to access data, except in cases where there was an added element of control, but generally rather it was to coerce and monitor victims. Also, this research has opened up new avenues for us to continue to study tech abuse in the UK legal system, and also hopefully encourage bodies such as the CPS to apply more technical acts like the CMA to kind of more social dilemmas such as domestic abuse. Also, it's been shown through this research, unauthorized access can be and frequently is a regular feature of IPV. Therefore, prosecutors should be alert to consider the CMA whenever there is an instance of unauthorized access to technology. And those making charging decisions in these IPV cases really do need to be adequately trained concerning the 5 offences that have outlined in the Act by Fran earlier. We also want to raise attention that abuse through telephone and other communication devices, so email, social media, WhatsApp, etc., did dominate our sample. So we haven't yet really observed the more sort of sophisticated or emerging technologies such as smart IoT devices. However, I think, we think it would, be really interesting to continue to monitor the legal landscape because, as these types of digital tools become more prevalent in society, it'd be interesting to kind of see how that changes in terms of the technologies that are arising in these cases. Also, it's important to point out that due to the vagueness and kind of lack of detail that were in some of the judgments that I mentioned earlier, it's not always possible to undertake a really nuanced evaluation of tech abuse, because we were seeing details sometimes like hacking into computers, or there were other forms of abuse. So obviously it's quite hard to kind of really deduce from those general statements exactly what's going on. So whilst the CMA itself is really detailed about the kind of offences that must occur, broad phrases such as hacking do not provide kind of the necessary level of information about the kind of technology that it is abused or the method that is being used by the perpetrator. And one of the last things to touch on quickly is the murder of Shayna Grice, the case I mentioned just briefly when I was talking about the results, is a case of, particular significance for a different reason, which is that this case really emphasized the complexity surrounding IPV relationships, because as well as the fact that it uncovered a myriad of police failings when it comes to emergent but possibly still unknown forms of coercion and control, and despite warning signs and also the fact that Grice contacted the police several times regarding Lane's behaviour, the police did not take her case nearly seriously enough as necessary, which obviously then very sadly left her in a very dangerous and vulnerable position. And this case obviously depicts the most severe outcome of tech abuse within our sample, and really highlights how technology, and in her case it was a tracker on her car, aided the offender in perpetuating the abuse against his victim. So obviously, we really consider evaluating the applicability of the CMA for IPV and specifically tech abuse offences to be, of great importance. And as we've seen through the COVID-19 pandemic, through statistics that have come out, tech abuse is just rising, and understanding historic domestic abuse and CMA cases can only give law enforcement agencies and the CPS a powerful tool to charge tech abusers, but also can help the research and practitioner community to kind of develop an awareness of different digital systems that are out there, and the kind of harms that can result from these digital systems.
Fantastic, thank you. So just turning to limitations quickly within our study, there are 4 main limitations that we found. First of all, I've already alluded to this, missing magistrates and Crown Court cases. So there wasn't always the documentation so that we could look back and see what had been through the court. We're well aware that there had been a number of cases that weren't recorded, that weren't publicly available, that we couldn't document and include Secondly, we've put here prosecution. So some of the cases mentioned the CMA, but perhaps without the details of the offence or the potential offence. So, for example, if you're looking at a case that's primarily about extradition or about family law proceedings, and there was something in there that said this could have been an offence under the Computer Misuse Act, there might not necessarily have been that level of detail about what that potential prosecution could have been. Thirdly, we found it quite difficult to track court cases through the legal system. So we're only really able to get access to the High Court decisions. That's only sometimes Court of Appeal and Supreme Court. So that's made it a little bit difficult to see where cases have gone. Or we might be seeing judgments that relate to a preliminary hearing or a specific side issue within a case rather than the actual outcome. And then fourth and finally, the level of detail in the documents associated with the court case hasn't always been particularly clear. So, for example, if a judgment is primarily dealing with a different issue that isn't about tech abuse, perhaps the level of detail about the relationship, for example, between the two parties might not be as full as we would have liked it to have been.
Thank you. And in light of these limitations, but also the opportunities that have opened up through this very short pilot study that we've conducted, we just want to give a brief snippet of where we plan to take this research next. So we have been very thankful to receive recently funding to hopefully continue this research. And we really want to continue the analysis of the database, especially in regards to the domestic abuse cases, which really showcase that there is a lot of tech abuse happening in UK courts. But we want to analyze what type of tech abuse offences have occurred and whether there is, an omission here that would have allowed perpetrators to be prosecuted through the Computer Misuse Act, but it hasn't been done because it wasn't considered, but also whether this has affected the sentencing outcome of the length of people having, for example, been imprisoned, for example. We also started, and we will continue to use FOI, so freedom of information requests, far more carefully, especially because we feel that because the court cases are so limited in the amount of information that we can see and receive, that, for example, through complementary FOI requests and very targeted both to the CPS, but also police forces, we could add to the information of the existing court cases that we have, but also find other court cases that might not be in these higher level court realms that we normally receive data from. We also want to add a level of news media analysis to this analysis, insofar as there's a lot of discussion in, like computer magazines and tech magazines on CPA, on Computer Misuse Act cases. And we want to, again, analyze how, for example, IPV may have featured in these articles. But last but not least, we think the nuance will only be achieved through semi-structured interviews with judges that have been involved in the cases that we've observed, with prosecutors. And so we're very keen on expanding this work and getting more information about the cases that we have found out, and also expanding on the ones that we have not yet analyzed to this date. And hopefully this will give what Francesca has said, this understanding of the nature and the scale of tech abuse as it occurs in the UK, but specifically the England and Wales court, but also gives us information of how we can better use the legal instruments available to us at this moment of time, such as the CMA, in emerging abuse cases that involve technology. And with that, I want to thank everyone for listening and joining us, and we want to